This presentation is on the Rape Shield Rule, which is found in Rule 412. This is another long, somewhat complicated rule, so please read the rule first and also the assigned text, and then I'll give you a short overview of the rule before we address the hypos in class. We're going to begin with a hypo. Let's say that Doug meets Pauline in a bar and goes back to her place. They both agree that sex occurred. Pauline says that Doug raped her. Doug says that Pauline consented. Can Doug introduce evidence that Pauline is promiscuous and or that Pauline had sex with two other men, George and Marty, last week? Before we even look at the Rape Shield law, let's think about how we would analyze that question under the other rules that we've just studied. Your first response might be no, Doug can't introduce that evidence because it's a propensity argument. Doug is arguing that Pauline has a propensity or a tendency to consent to sex with men that she has just met. Therefore, their encounter was likely consensual. As we know, Rule 404A.1 prohibits propensity arguments. So why do we need this Rape Shield rule? Doesn't 404A.1 already exclude evidence of Pauline's promiscuity if we want to exclude that evidence? The answer is that 404A is not an airtight rule. In fact, it has two important exceptions that might well apply in this case. First, in 404A, we have an exception that allows the defendant to introduce evidence of the victim's pertinent character trait, as long as it's in the form of reputation or opinion. So the evidence about Pauline's promiscuity might come in under that exception. In 404B, we have another exception that allows evidence of specific acts for non-propensity purposes. And in rape cases, defense counsel might come up with a plausible argument to introduce evidence of the complainant's promiscuity. So defendants have several avenues for introducing evidence of a victim's sexual behavior and sexual character. Prosecutors and victim advocates wanted to do more to protect the privacy of rape victims and to encourage victims of rape to come forward. They pressed for exclusion of all evidence related to the complainant's sexual behavior. At the same time, we want to allow defendants to raise legitimate defenses, and sometimes the complainant's sexual history is legitimately relevant. Courts and legislatures have designed fairly complex rules to try to strike this balance. Okay, so let's do an overview of Rule 412, but before we do, let's put it in context. Rule 412 trumps Rule 404. If you see that the case involves the Rape Shield rule, you can bypass Rule 404 and go straight to Rule 412. Let's look at the overview of Rule 412. 412A sets out the prohibition. 412B sets out the exceptions. The exceptions are divided between criminal cases and civil cases. B1 includes exceptions for criminal cases, B2 for civil cases, and then 412C sets out the procedure for the court to determine admissibility. And the key aspect of that is going to be balancing. All right, so let's walk through the steps. The first step is to ask, is the evidence within Rule 412's prohibition? First, the case must involve sexual misconduct. And secondly, the defendant must be offering evidence of either the victim's other sexual behavior, and this includes actual physical conduct, evidence that implies sexual activities, such as evidence that the victim was using contraceptives, has VD, is living with her boyfriend. And it also includes activities of the mind, fantasies, dreams, and that sort of thing. The rule also includes evidence about the victim's sexual predisposition. The advisory committee's note makes clear that this broadens out other sexual behavior to include evidence which may have a sexual connotation for the fact finder, such as the victim's mode of dress, speech, or lifestyle. Okay, so step one, we determine whether it's within the prohibition. If it is, then you have to determine whether it's a civil case or criminal case. Most of these are rape cases or sexual assault cases, so they're criminal cases. But it could be a civil case for sexual harassment, for example. Okay, if it's a criminal case, then you need to consider whether it falls within an exception. Rule 412 contains specific exceptions for criminal cases. Under 412B1A, there is an exception for a specific instance of the victim's sexual behavior to show that someone else was the source of physical evidence, such as semen or injury. We have a second specific exception for specific examples of the victim's sexual behavior with the defendant. If the defendant is using this exception, he must be offering the other sexual behavior to show consent. If the prosecutor is using this exception, the prosecutor can use it for any purpose. And typically that would come up for a prosecutor in a child molestation case where the prosecutor wants to introduce other evidence that the defendant had sexual relations with the child. And then we have a third exception for criminal cases, and this is sort of a catch-all exception. It applies where the evidence is so important that exclusion would violate the defendant's constitutional rights. In order for this exception to apply, you have to show that the evidence is so important and so powerful that it would violate due process to exclude it. To meet that high standard, it's going to have to be strong and specific evidence. Most examples from the courts involve situations where the other sexual behavior shows that the victim had a motive for claiming rape. All right, then we go on to step 3, and that is to conduct a balancing test. The proponent first must give advance notice, and then the court must hold an in-camera hearing to do this balancing. In a criminal case, again, the evidence has to have first fit into an exception and then must meet a 403 balancing. In a civil case, the court goes into a reverse 403 balancing. Please note that in a civil case, there is no specific exceptions that have to be met first, but the balancing standard is tougher. It has to meet the reverse 403, which gives us a strong presumption against admitting the evidence. Okay, so as I said, this is a complicated rule, and I've got a flow chart here for you for criminal cases. We see the first step is the general prohibition, the box in green. There are 3 specific exceptions. You must fit within one of the specific exceptions to use the evidence, and even if you do, the evidence still must pass the 403 balancing test. Let's compare that to the flow chart for civil cases. This is a simpler analysis. You first have to determine whether it falls within the general prohibition. If it does, then you go straight to the balancing, but now it's a reverse 403. Okay. And just to be sure you're clear on the difference between a reverse 403, which is what we find in Rule 412B2 for civil cases, and a regular 403, which is what the court uses after finding a specific exception in criminal cases. When you're using the reverse 403 for civil cases, there is a strong presumption that the evidence will be excluded. The court must exclude unless the probative value of the evidence substantially outweighs the risk of prejudice. Okay, so the burden here is on the proponent. This rule also specifically permits consideration of harm to the victim. Compare that to Rule 403, where there is a fairly strong expectation that the evidence will be admitted. Of course, remember, in this context, it first has to have fallen within one of those narrow exceptions. Okay, but if it does, there's a strong expectation that the evidence will be admitted unless the prejudice substantially outweighs the probative value. Here, the burden is on the opponent. Okay, and then just a few more details on the procedure that the court uses. Again, the party has to give notice to the court, opposing counsel, and alleged victim 14 days before the trial. The court will then conduct an in-camera hearing, which means an in-chambers, secret, sealed proceeding with the parties and the victim to determine if the evidence is admissible. It is at this hearing that the court does the balancing of probative value against prejudice. And again, in criminal cases, the court's using 403, and in civil cases, a reverse 403. That concludes the overview of Rule 412. Please take the quiz on TWEN, and I'll see you in class.